Unfortunately, I'm here to report the breaking, developing story of a massive Second Amendment loss coming out of a federal court based out of Missouri. A federal judge has just overturned a Missouri sanctuary state law, in essence, that declared that all federal gun laws are invalid if they don't have a state level equivalent. The law, known as the Second Amendment Preservation Act, further declared that federal supremacy clause was not applicable to any manufacturing, ownership, and use of firearms and firearm accessories or ammunition within the state because such a law exceeded the scope of federal government authorities. And I'm going to explain what the supremacy clause is because it's going to be really important. Now, the state law also goes on to make it illegal for state employees and law enforcement to enforce firearm laws declared invalid by the Second Amendment Protection Act, and also further creates an actual duty for courts as well as law enforcement officers to protect the rights of law-abiding citizens to keep and bear arms. Any law enforcement officer or state or local government employee in Missouri who tries to enforce the invalid federal laws could be the subject of a lawsuit where they are facing, they being the department or agency or legal group, is facing up to a $50,000 fine per employee hired by the law enforcement agency. So, lawyer math here, if you have a 10 employee police department, you're looking at a $500,000 maximum fine. Also, attorney's fees as well as costs may be awarded to the plaintiff who sues to enforce this provision. The Second Amendment Preservation Act was passed in 2021. All right, so there are three things that I want to bring to your attention here. No, I'm not going to get super nerdy on law. If you want to know more about specifics, be sure to let me know in the comments section below. I'm keeping this high-level breaking news. So first off, we're talking about the supremacy clause and what's going on here. Well, what the judge is saying is that, look, this entire law, first off, that you passed is 100% unconstitutional. In fact, the judge's exact words were that the law is, quote, invalidated as unconstitutional in its entirety, end quote. Yeah, this judge spiked the football on the Second Amendment Preservation Act. The reasoning has to do with what I mentioned before, which is the federal supremacy clause. So what is the federal supremacy clause? Well, it actually comes from Article 6 of the United States Constitution. So no, this is not some sort of ATF ruling or something like that, although kudos if you thought about that before I said it. We're talking about the actual Constitution in and of itself, Article 6, which says in part that it shall be the supreme law of the land, and judges in every state shall be bound thereby. And what we're talking about is the fact that, look, if you have a conflict between federal law and state law, federal law wins. That's the federal supremacy clause. And I'll give you two guesses why it was named that way. So the important part for what the judge is saying is, look, I do see a conflict here. And because there is a conflict, federal law wins. That's, in essence, just distilling the judge's ruling. That's where they're going to. Now, wait. I hear your keyboards clacking. The Second Amendment, you say, that's also part of the Constitution, right? And Missouri's basically saying that, well, look, the feds must respect the Second Amendment. This is kind of like from the Chronicles of Narnia, right, where Aslan says, but look, there's a deeper magic here. If you get me, please let me know in the comment section on that. And if you did get that, then you're absolutely correct. That's in essence what they're saying is, look, there's a higher law of the land. You've got the Second Amendment, which is part of the Constitution, versus all these different federal laws, which I'm sure many of you watching, as well as, of course, the folks who voted for this in Missouri, are saying, yeah, there's a lot of federal gun laws and rulings and so forth out there that, you know what? I don't think that this passes constitutional muster. Therefore, Second Amendment Preservation Act. The judge is saying no. And here's why the judge is saying that, and don't direct your ire at me, I'm only the messenger. I'm literally the messenger here. The judge is saying, look, what you're making here in Missouri is a political point. If you do think that something is illegal, some sort of federal law is illegal, the proper thing to do is to sue and have a court strike it down as being unconstitutional. That's the mechanism, so would say this judge, I'm sure, for how you deal with that. Again, if the law is unconstitutional, it will be struck down. If it is not unconstitutional, then where there is conflict, we have supremacy clause. But wait, I hear you saying, for those of you who may be really interested in the nerdy text of this law, which I will link in the description box below, you may also be seeing interstate commerce. Look, I'm not going to make this a 5-hour video about interstate commerce, but yes, in essence, if the feds lack jurisdiction due to lack of interstate commerce, then I suppose that could be a defense to the criminal charge. But if you want me to go down that rabbit hole, again, let me know in the comment section below. I'm trying to keep this high level right here, folks. All right. So, is now, by the way, a good time for me to mention the fact that this judge, which struck down the law, may have been appointed by a president that I'm guessing many of you view as being anti-gun? Could that be relevant? I don't know, but I'm just going to slide this part in there at that point if you couldn't already guess that. Before I get into points number 2 and 3, if you've not already done so, please take a moment to click like on this video, as well as to share it around to show your support, not only for this channel, but also for the Second Amendment. Also, please drop comments down below in the comment field and tell me what you think about this law, what you think will happen, whether or not your state, your city, your sheriff, your county, your municipality has done something about Second Amendment and how you see this impacting you, if at all. Now back to the show. So the second and third point that I want to talk about are really just going to be rolled into one, and that's the 10th Amendment and the anti-commandeering doctrine. 10th Amendment, I hope you've heard of that because at least you probably covered that in your 8th grade civics class, which I'll give a refresher on. 10th Amendment, we're talking about, and I'm going to read it right here because it's so short, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Translated into, well, the year 2023 language, basically, look, something that the United States Constitution has not specifically said that the government, the federal government, has the power to do, that's reserved for the people, that's reserved for the states. So broadly, this reserves everything that's not mentioned by the Constitution for the feds to the state. So really what this does is this strikes you into a discussion about something called federalism, which is really something that deals philosophically with the distribution of power or power sharing between states and the federal government, something that our founding fathers were extremely concerned about. If you want to see a video talking about the Second Amendment and federalism, also let me know in the comment section below. Let's bring in the anti-commandeering doctrine, because this is something that most of you have probably never heard about. The anti-commandeering doctrine says that the federal government cannot require states or state officials to adopt or enforce federal law. Now, the Supreme Court created, or some might say discovered, the doctrine out of the 10th Amendment, as well as related federalism principles in 2 U.S. Supreme Court cases, both from the 90s. First one being New York versus United States in 1992, second one being Prince v. United States in 1997. But outside the court's rulings in those cases, the doctrine, many have said, has no basis in actual constitutional law, at least not literally constructed. Once more, since I'm not trying to make a 6-hour video, if you want a deeper dive on those cases, and by the way, Prince v. U.S. might be especially interesting for many of you because it dealt with the actual Brady Act of 1993, which amended the Gun Control Act in 1968, whereby the Supreme Court of the United States actually struck down a provision of the Brady Act as being illegal. If you want to see more about that, again, let me know in the comment field below. So briefly, let's now tie these together. So we've got these issues, the 10th Amendment, federalism, and the anti-commandeering doctrine. Because you could try to make an argument that the federal government is trying to commandeer local and state law enforcement where state law is silent or where federal law is arguably illegal. And again, this is a super short version of it. And Missouri would say, look, all we're in essence doing is invoking the anti-commandeering doctrine by saying we're not going to have our employees, whether they're law enforcement, whether they're municipal government or anything else, get involved with anything that's out there at the federal level, okay? Feds are going to do something, that's on them in essence. Now, again, yes, Missouri also had we're going to basically protect and to stop the feds from coming in, from interfering with the right to keep and bear arms. But once more, for the longer version about how all these things are intersectional and could play together, let me know in the comment field below. And if enough people are interested in it, then I'd be more than happy to do a video about it. So the case now where we stand, so it's been struck down. So the Second Amendment Preservation Act is basically done as of this moment. But of course, the lawsuits will go on. It will now be appealed, it looks like, to the 8th Circuit Court of Appeals, and we will see what happens. Keeping in mind that, of course, when a plaintiff files a lawsuit, they get to do something that we call in law forum shop for the judge that they want. This means that the plaintiff, those being the people who are seeking to strike down the Second Amendment Protection Act, can stack the deck in their favor to win by filing the lawsuit in front of the judge who they think will be the most favorable to their views. They do not necessarily, however, get to do that on appeal to the Federal Circuit Court of Appeals, especially in this case where we're just dealing with one particular state law, different if we're talking federal issues. Also, if you want to see, by the way, how the Second Amendment sanctuary movement can be legally compared and contrasted with immigration sanctuary cities, let me know in the comment field below, because while I was kind of scripting this out and doing research, it had me thinking about this, and if I'm not alone in that, let me know, and again, I'll be reading the comments. And by the way, this is a special treat for those of you who stayed this deep into the video. I have a special sneak peek announcement. In the next few weeks, I will be releasing a massive multi-video series exploring the incredibly racist history of gun control. So be sure to subscribe to make sure that you do not miss that, because you will not want to miss that. I've been working on this for 3 months at this point. If you want to stay atop of this case as well, if you want me to follow the developments through the 8th Circuit Court of Appeals and possibly all the way to the U.S. Supreme Court, then once more, let me know in the comment field below for that as well. If you've not already done so, please take a moment to click like on the video, subscribe to the channel. Again, doing both of that helps get our videos out there, helps the channel grow, and it helps to support the Second Amendment, as well as, of course, sharing it around with all your friends, social media, email, all that kind of good stuff. Both myself and the algorithm, thank you for staying this long, and we will see you in the next one.